Hey there, welcome to the Courtroom Files. So, the stated goal of this channel is to bring you things that you don't see.
Alright, let's unpack this. The couple already got their divorce, but the property split? Never finalized. Now one of them's dead. And that, my friends, is where Tennessee law starts getting messy. Because if the divorce wasn't truly final, technically, are they still married? Yeah, this is about to get wild.
Every day. We can show you the same thing over and over, but we work really hard to find moments in these courtrooms that represent something new, something unique, something odd. We definitely have that today. So this revolves around a divorce proceeding in Judge Wolfe's court. Now, there's nothing unusual about divorce. Sadly, that's all too common, but we guarantee you haven't seen this before. So a divorce decree had already been granted by Judge Wolfe, but one of the things that still needed to be worked out after the decree was the property matters. Unfortunately, the husband has since passed away. Now the wife or ex-wife, depending on how you look at it, I suppose, is back in court seeking to have that.
Now, divorce court is rarely calm, but throw in a death, disputed inheritance, and an unfinished property division. That's not just courtroom drama. That's the legal version of a plot twist no one saw coming.
Divorce decree thrown out, essentially making them married again and making her a widow, which we suppose would put her in a better situation from a property and inheritance standpoint. That's our guess anyways. We'll let you be the judge. But that's what's going on. Interestingly enough, her lawyer has case law that she's citing, which seems to support her point that this should be thrown out. Like I said, very unique. So give this a listen. You're definitely going to hear some parts of law and case law that you haven't heard before. Towards the end, the judge mentioned something interesting regarding how this case law was filed and how that affects how he should view it and how he should use it. So there's a lot going on that's very instructive here, and we really like Judge Wolfe because he tends to be a good listener when the arguments are put in front of him, but he also puts a lot of thought into his decisions. So give it a listen. Let us know what you think in the comments about the judge's final decision on how to proceed with this. Put a like on the video if you enjoy it. Subscribe to the channel if you have not already, and let's roll the game film.
Your Honor, we're here on a motion to dismiss that was filed by Ms. Sunny Stevens on behalf of Elizabeth Diane Walker. We're ready to proceed.
Stevens, your motion to dismiss, is that correct?
Yes, Judge.
Quick legal primer. Motion to dismiss is basically saying, Judge, this case shouldn't even continue. But what's fascinating here is why. The wife's attorney is arguing that since the husband died before the divorce was finalized, the whole thing should be erased, meaning she'd legally still be his wife. Sounds strategic, right? Let's see if the judge buys it.
But also, Judge, I don't remember if I filed the case law, and I don't know if Ms. Williams has a copy of that, but I have a copy. I'm not sure if Your Honor has it. I don't recall if I filed that or not. I believe I did, Judge. But if not, I have a copy of that for everyone.
Well, the file contains a copy of your motion to dismiss, in which I think there is case law cited, but I don't believe that there is.
Yes, Judge, and I briefed it all. And I believe that was filed, Your Honor, the brief, but perhaps the law was not. Well, Judge, as you know, Mr. Walker, he filed for divorce July 23rd, 2023. On March 13th, 2024, you granted an interlocutory order granting the divorce, but at that time, the property had not been divided. Mr. Walker died on May 24th, 2024, and that was before we had any final property division that was made, and there was no final order entered prior to his death. On May 24th, 2024, counsel for plaintiff filed a suggestion of death, and on August 29th, 2024, an agreed order was entered to substitute the descendant's estate as plaintiff in the matter with the issues pertaining to marital property division. A Rule 5402, which I'll read it for the record, Your Honor, but when more than one claim for relief is present in action, whether it's a claim, counterclaim, cross-claim, or third-party claim, or when multiple parties are involved, the court, whether at law or in equity, may direct the entry of final judgment as to one or more, but fewer than all the claims or parties, only upon express determination that there is no just reason for delay, and upon the express direction for the entry of judgment. In the absence of such determination and direction, any order or other order, form of decision, however designated, that adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties shall not terminate the action as to any of the claims or parties, and the order or other form of decision is subject to revision at any time before the entry of judgment, adjudicating all claims and rights and liabilities to all parties. Additionally, Rule 3, Tennessee Rules of Appellate Procedure provides that any order that adjudicates fewer than all the claims or rights and liabilities of fewer than all the parties is not enforceable or appealable and is subject to revision at any time before entry of the final judgment adjudicating all the claims, rights, and liabilities of the parties. So what we are saying, Judge, that the order awarding the husband a divorce was not final and was subject to revision at any time prior to the entry of the final order adjudicating all the claims. In the case that's cited, McMahan versus Butler, Court of Appeals of Tennessee, which is, I think, on point and almost mirrors the facts of our case, and that's the case that we have today before you, Judge, that our parties wanted a divorce, you granted a divorce, the divorce was granted subject to the final property distribution. Unfortunately, plaintiff died, so that was never done. So what we believe, and what I believe the Tennessee Court of Appeals found, the death of the husband in that case terminated the action for the divorce, and it must be dismissed. And the court reasoned that there was only an order declaring the parties divorced, but as Your Honor knows, the property settlement agreement or the final order was not determined.
Notice how the lawyer keeps emphasizing that the divorce wasn't final. This is key. In most states, if there's no final judgment, like a property division or official decree, the court can technically reopen or dismiss the case. So, this isn't just emotional, it's financially tactical. Being the widow means inheritance rights, pensions, property, a lot of money on the line.
In our case, and also in this case that I'm referencing, so the order declaring the parties divorce was nothing more than an interlocutory order and not the final order. So based on that, we're asking the court to dismiss the order. And on page 2 of what's being cited, Judge, at the very bottom, the court noted, however, that this is not the situation here. As you read through the case, the wife had not agreed to division of the property. In fact, the property rights of the parties were being litigated, and the final decision on the aspect of the case had not been made. Under those circumstances, we think the death of the husband terminated the action, setting aside all preliminary orders and terminating the power of the trial court to make any further orders on the case. And that's what we're basing our motion on this morning, Judge. And again, this was also briefed. It's very, very brief, a few pages long, in addition to the case law that's been provided.
And your client wanted a divorce, correct?
She did, Your Honor. She did want the divorce.
She filed an answer and a counterclaim seeking a divorce.
The divorce, but not the division of the property. As Your Honor may recall, the day that you did grant the divorce, I had that objection that he testified that he was in ill health. He didn't know how long he was going to make it, and the property was still undivided at that time.
And what disadvantage to your client is there by sustaining the granting of the divorce? How is your client prejudiced by the granting of this divorce?
Well, Your Honor, the other party isn't here to determine what is marital property. When my client left, there was an order of protection. She literally had the clothes on her back and a pocketbook, a purse. She still has personal items, 20 plus years of pictures, photos, clothes. She's been enjoined from going to the home. Now there's a probate matter that's been opened, so everything is subject to the substitution of counsel coming in place of the decedent. So what is going to be marital property and private?
You had filed a motion to substitute the estate for Mr. Walker based upon his death, correct?
Yes, Judge.
Right. So if you're seeking to have the estate substituted for the decedent, then it would seem to me that that's a position that said, I want the estate to be involved in it so that we can litigate these issues, is it not?
Yes, Your Honor, but that was prior to finding this case law that's spot on to what we have now, that according to the Tennessee Supreme Court, terminates any power of the trial court to make any further orders in the case. So that's why we would ask that based on that it be dismissed and follow according to what McMahan and Butler has already set aside.
And for example, the property that was owned by him prior to his death, or prior to the marriage, the real property that was owned, by dismissing this case and rendering the granting of the divorce moot, so to speak, it would obviously be to your client's advantage, because then she would be an heir to the estate, being his wife, and would have the right to inherit at least a 1/3, if not more, correct?
Absolutely, Judge.
And that would be more advantageous to your client than having to have a litigation where the issue would be whether or not she had actually contributed to the increase in value or preservation of that.
Well, Your Honor, despite that, the Supreme Court says, it says it right here, Judge, that under those circumstances, the death of the husband terminated the action setting aside all preliminary orders, which was the interlocutory order that I'm arguing.
Stevens, what the Court of Appeals decision says, I'm just asking for questions on the record about the reason why your client wants to set this aside is because it's much more advantageous to her to have an estate rather than the divorce action.
No, Judge, I don't think it's more advantageous. I think it's the law. I think it's what it states here, and that's why we're arguing it. Is it advantageous? Perhaps, perhaps not, but that's just what the appeals court determined in this case, and that's what we're arguing, Judge.
Anything else?
No, Your Honor, thank you.
Your Honor, if I could, just from here, if that's okay, I think the microphone is on. Your Honor will remember this case was filed, and we had a substantive hearing before Your Honor on the 22nd day of January, wherein proof was presented. Discovery was taken in this case. And again, Your Honor made a finding at that point in time that based upon the sworn testimony of the respondent, that being Mrs. Walker, her answers found in sworn discovery responses and the finding of the court of the plaintiff's current medical condition necessitates that the court award a judgment on the pleadings and grant an absolute divorce to the plaintiff on the grounds of inappropriate marital conduct of the defendant, and hereby restores both parties to all rights and privileges of unmarried persons. The issue of division of assets and other related matters is reserved pending a final hearing in this matter. Your Honor specifically will recall that Mrs. Walker threatened the life of Mr. Walker, that he fell, she left him for dead, and was effectively trying to kill him so she would inherit from him. That's what the proof showed. This
is argument. I'm not accepting what you're saying as fact. I'm just accepting it as argument.
Well, Your Honor, and again, that's what the proof showed, what Mr. Walker testified to. Mrs. Walker admitted in her discovery. The case that was presented is very distinguishable in the fact that the husband in this case withdrew. In the case that was cited in the McMahan versus Butler case, the husband withdrew his complaint for divorce and the wife proceeded only on her complaint. The husband had no pleadings before the court, and at the hearing he withdrew his complaint. Mr. Walker was seeking a complaint, was seeking the divorce, and there was an admission on her behalf, on Mrs. Walker's behalf, and Your Honor found an order of protection was necessary in this case, extended the order of protection that had previously been issued in this court, and found that she was a credible threat of harm to Mr. Walker. Mr. Walker did die after the fact. And the issue of division of assets is reserved. A suggestion of death was filed before this court, and the estate was substituted as a party. And Your Honor, what's interesting to note is that under section 30, under 36, section 1, grounds for divorce are separate from the division of assets provision under the law. Is again, the in personam jurisdiction of the divorce itself was met prior to the death of Mr. Walker. And what's unique in the respect is that originally there was a motion to set aside the judgment of the court that was filed with this court. I did send Rule 11 safe harbor letter to council based on the filing of that motion to set aside. She struck the motion to set aside the order and then substituted it with this motion to dismiss. And of course, I didn't have 21 days notice, so I would have, if I had had 21 days notice, I would have filed another safe harbor letter and asked that it be dismissed. But Your Honor, the fact is that the grounds for divorce is separate from division of assets. Specifically, the grounds for divorce cannot be used to alter. The statute clearly states that grounds do not affect the division of assets. And so Your Honor specifically reserved that issue. And I think this case, again, as I said, it's distinguishable. And there's a number of things in this. Again, counsel handed it to me 2 minutes before, and I'm aware of this case. But the fact is that each case is unique. This court has the authority, based on the circumstances, to grant a divorce prior to the division of assets. And this case is one that is paramount to that because Mr. Walker was the victim of domestic violence. And that heightens the level of that he needed to be protected from the defendant. And now the defendant comes before this court already admitting that she was a credible threat of harm to her now deceased, to Mr. Walker, and seeks to set that aside and financially benefit from her own ill treatment.
Whoa, this changes everything. The husband wasn't just sick, he was allegedly abused by the wife. So now the moral question hits hard. Should someone accused of threatening their spouse's life be allowed to benefit financially after their death? This is where law and justice collide head-on.
And again, the specific finding of the court was to protect Mr. Walker. He was frail. He was terminal at the time. And this was all before the court in January of this year when the court was granting the divorce. And I think it's a unique set of circumstances. And again, it doesn't apply. This case does not apply because the unique set of circumstances in this Walker case was you were doing it for the protection of the plaintiff, Mr. Walker, due to the ill treatment and the threat of credible harm of Mrs. Walker to him. And again, the issue of division of assets is still there. And again, they have filed in the estate case.